It's Law Talk, first Wednesday of the month here on Afternoons Live. That means Bruce Ringstrom Jr. in studio, Dane DeKrey in studio. Ringstrom, DeKrey, Law. They are criminal defense attorneys, and they're friends of the show, and they take all your questions at 35270. Bruce Ringstrom Jr., welcome back.
Tyler, it's good to be here.
Good to have you. Dane, I want to say the same, and I will. Good to have you back.
Thank you. That's nice of you.
That's the nicest I'm going to be for the whole hour.
Yeah.
So it's all downhill from here, brother.
I'll take it.
Let's get this out of the way. There's been a high-profile situation in Minnesota, and it involves a Democratic state senator allegedly breaking into her stepmother's home for what I would say are family conflicts. And it has been now publicly stated that she has turned to your law firm for some representation. Bruce Ringstrom Jr., I don't know what I can and cannot ask on this situation, but a lot of people are talking about it, and I think that lends itself to my first question is, when you have a high-profile candidate like this, and that is a politician that's been talked about all over the news, how does that provide a barrier for you to do your job? Does it?
Well, to a certain extent, it does. Anytime a high-profile client is faced with a criminal case, the media is as interested in their celebrity, their professional obligations as they are with the criminal case. This one is getting particularly complicated because, of course, there's a lot of things going on in the legislature right now. Dane and I are expressly focused on defending this person in court in Becker County. We are only reluctantly involved to the extent that we absolutely have to be in the political dimension. We don't want to be involved in that in any capacity, but it is our job to protect her, and we will do just that.
The politics adds a whole other level here because I've been guilty. I mean, we talked about it, like you say, about the status. I mean, she is a state senator that is tasked with, representing a district. We don't need to go into all the details here of, that night. It's been all over the place. But the politics of it comes in because of the majority and what they are, what narrow it is. I mean, when you have to represent, so I'm curious, when there's like an ethics investigation that's going on, do you represent in those scenarios too, or is it just in a courtroom? How does that work on just a criminal defense side? Because you have the politics and then you got the legal side, right?
Right. The only time that we get involved with the politics side is when the two intersect. And so in the ethics investigation that you just mentioned, there may be questions at that investigation that would require the senator, our client, to have to make statements that could be damaging to her criminal case. And so we will be involved at any hearing where we think there's an intersection of the criminal aspect, because that is what she hired us for, and that is what our job is about. And so, as Bruce said, that's the reluctant cross-section of politics and law. We would prefer to just be dealing in Becker County and representing her like any other of our clients. But because of the dimension, we will have to spend a little time in St. Paul helping her navigate the ethics investigation.
Aside from just this story, and we can take it national, I mean, Donald Trump's on trial every day. He's a high profile. Obviously, he's a former president. We talk about Ray Holmberg, who's a state senator here. You can take other celebrities that aren't just involved in politics. So when Bruce talk about the celebrity, the status that people just want to talk about it. When I think about this coming to a potential trial, what you want to get a jury, how much of an impact does what we do on to these shows impact the ability to find an impartial jury? I mean, is it as robust as, or are we just egotistical in media thinking that, hey, we have all this sway and all these different capacities, or does it have a real impact?
It does have a real impact because when a jury is picked, both sides, the prosecution and the defense, as well as the judge, are inquiring of the veneer, the panel of prospective jurors, what they know about the case, what they know about the defendant, and that tends to cause more good prospective jurors. By good, I mean good from the perspective of both the prosecution and the defense, from not being seated on the sworn jury. It means it takes much longer to get a jury, and it can mean it is impossible to seat a truly fair jury, that there are people on that jury who have misrepresented their biases, and it can't be sussed out. So we understand the media's motivation, but it is a problem from the perspective of the criminal justice system.
35270 Adventure RV is how you can get your questions answered if, in fact, you know a friend or if you are that individual that says, hey, look, I need some criminal defense advice. I need some representation. These are the two to do just that. This isn't necessarily a question that comes in for you two, but I'm going to direct it at you two. We just heard in the KFJ News update about a North Dakota situation when it comes to Cass County Sheriff Jesse Johnner. He was called from a landowner, suspicious activity as was reported. And now there's questions about the status of immigration. Are these individuals here legally? And this is a comment that came in response to that, and I want to get your take on it as somebody that would represent potentially a client. Talking about, I think there's a suspicious car just a couple houses down from me. There's no evidence, just suspicious to me that there's anything wrong. Is that enough for law and authorities to go and hassle them? Not here, not in the USA, I believe. So when it comes to this situation, where a neighbor is kind of weirded out to call the cops on that person, what's your guys' opinion legally and criminal defense like on this?
Well, if that person ends up actually calling the police, that's usually what we call an anonymous tip by an anonymous informant. And the law says that standing alone is not enough for the police to go investigate or intervene. And you can imagine why, because you could weaponize that pretty quickly and start Gladys Kravitzing your neighbors whenever you didn't like what they were doing. But if the police then are able to take that tip and then go substantiate it in some way to give more credence to the claim that there is something suspicious, then that may give rise to them to begin a criminal investigation. But from what you said, that seems pretty threadbare, and I appreciate the comments understanding that just because it's suspicious to me does not make it suspicious to thee or objectively. And so I would urge caution to begin to look upon your neighbors suspiciously for those reasons, because that's a very slippery slope and it usually ends up in places that we don't like. Sure.
When it comes to the immigration status has been injected into this, right? And when it comes to jurisdictions, you have a Cass County Sheriff, which I don't fault Jesse John for going and taking the call, right? I mean, I think he's doing his job. That's my opinion. This adds a whole other level of, intrigue to it when it comes to, okay, now you got to involve the federal jurisdiction. I'm not sure where the question lies for you as criminal defense attorneys here. The proper channels is something that I'm sure you watch closely, though, right? So let's say, and it hasn't happened, but somebody that doesn't have jurisdiction goes and tries to get a warrant or do whatever it might. Does that muddy the waters quite a bit when it's a federal versus a county versus a state? Where do you guys come in on that? Make sure that the process is done correctly.
Well, Dane can speak more to this because he does a lot more federal work. But what I will say is many federal cases, if not most, begin with a state or a municipal law enforcement officer investigating. We have a federal trial coming up, and there is very likely going to be a state investigator who will be one of the government's main witnesses. So it's not surprising if there's a possible immigration issue that the investigation starts with a state or a city law enforcement officer.
Very good. That clarified that for me. If you got questions, comments, send them in. We take any and all at 35270. You can also call us at 237-5948. A couple of things I want to ask you guys about statute of limitations. What are they good for? Why do we have them? Is 2 years a national average or North Dakota? I'll get to that. Also, you guys just mentioned trial prep. You guys have been busy. I know you're going to be busy. I want to talk about that when we come back. It's Law Talk. Ringstrom, DeKrey are in studio. More next. Law Talk underway here. We do this every first Wednesday of the month. And once you look at the calendar, it is May 1st, and it happens to be on a Wednesday. That means Bruce Ringstrom Jr. and Dane DeKrey are in studio. 35270 is the Adventure RV Text Club to text in your questions. Statute of limitations is something that is often brought up, and I've seen it a couple of times here just recently when it comes, to scandals. And the intersection of alleged crime and politics again. But the reason I bring this up is I keep hearing the 2-year statute of limitations has or is about to eclipse when it comes to potential crimes committed. We don't even need to necessarily go into the details of what alleged crimes were there, but 2 years keeps getting brought up on the North Dakota side. Is is 2 years a national average? Does it depend on the type of crime? Why 2 years? And why is it important for statute of limitations, period, I guess?
So I don't know whether 2 years is a national average. I think most of the statutes of limitations in Minnesota are 3 years for misdemeanors, 7 years for most felonies, and then 9 years for sex assaults, actually 9 years from the date of report. So if a 10-year-old alleges that he or she were assaulted then doesn't report it until they're 25, law enforcement prosecution would have 9 years from that point. And then with murders, there is no statute of limitations. The policy purpose, why do we have statute of limitations? Because as a case gets older, memories fade. It becomes harder for defendants to build a defense because witnesses go away. And it's for efficiency of the criminal justice system. The government, and I think it's justifiable, has decided that more serious cases deserve a longer statute of limitations. And in the most serious cases, murder, there is no statute of limitations, which is why now we're seeing with a lot of DNA stuff, 50-year-old murders getting charged out.
Anything to add on that one, Dane? I mean, a great addition to it is fact is that the memories don't serve as well. And, I mean, there's a reason there to make sure that there's some equitable justice if there needs to be served there.
Yeah, it's a policy decision in a lot of ways. Different states have different numbers. Some keep them open longer, some don't. Also, with recent things like in the Me Too movement, there was a reevaluation of those types of statutes of limitations. You know, the Harvey Weinstein trial, there's just reversal in that case. Yeah. But, before those cases kind of came to the limelight, there was more definite, shorter statute of limitations. And now many state legislatures are either making them unlimited, like murder, or much longer. And so public pressure can change that dynamic as well.
You know, I think one thing that we get in every month about this is about DUI laws. And I think it was just not long ago that North Dakota had changed in that kind of look-back period. If you have a violation within, is it 7 years or whatever it is now, then that's going to be another strike and additional punishment for you. Is that kind of along the same terms, or is that something entirely different when we have that look-back versus a statute of limitations?
I think it is something different because it basically just decides what, if you're having a DWI, if you get a DWI today, how serious should we regard it if you've had 3 DWIs within the last 7 years? Whereas if you had 5 DWIs back in the 80s and you have a new one now, your pattern of behavior isn't as egregious as it used to be. Okay. Interestingly, though, I've represented people who are charged with a misdemeanor DUI, but they had a bunch of DUIs 40 years ago, and the Department of Public Safety, or the DMV, revokes their license for 2, 4, 6 years because the look-back period on the license revocation is forever.
Mm-hmm. Somebody's getting in some questions here. One, I'm going to preface that we'll come back after the break here because this is about child and paternity and all that. But this one comes in, cannot statute of limitations be extended in certain circumstances, for example, with juveniles? Any truth to what this texter says? When it comes to juveniles, can you statute of limitations be extended?
Well, that's kind of what I talked about. It's a complicated idea. Sure. Again, if a 10-year-old alleges that they were molested, but they don't report it until they're 25, even though in Minnesota there's a 9-year statute of limitations on sexual assault cases, it gets extended. You can't retroactively extend it because in the United States we have what's called there are no ex post facto laws. You can't say, we don't like what you did, but it's not against the law, so we're going to make it against the law now, and you're going to go to jail.
Very good. More questions coming in. I tell you what we're going to do is get you caught up with some KFGO news. Dane, you brought up Harvey Weinstein and the reversal. I want to get your guys' take on how and why that happened as well. And there was something that we left on the table last month when you guys were in when it comes to evidence through electronics, through cell phones. We didn't conclude on that. So I want to bring that back up. And plus you guys have been so dang busy and trial prep. We'll get back to that in just a moment. Join the conversation, 35270. I see the establishing paternity in North Dakota. We'll get their take on some of that if they have any thoughts on that text that came in. Plus anything else, call us, 237-5948. It is Law Talk right here on KFGO. We're back to Law Talk here on KFGO. Bruce Ringstrom Jr., Dane DeKrey are the two guests in studio taking all of your questions We'll get the details if you need to further question their expertise and actually get some representation. But I'm going to throw this one out to you guys. And I know that there's all different levels of, lawyer, attorney. I mean, same with a doctor here, but they sent in the question, so I want to ask it. Trying to establish paternity in North Dakota, the child's going to be forced. The father was incarcerated for almost 2 years and would like to establish paternity, not custody, as he knows he is not ready for that until he gets some things done for himself. The mother has her own issues, and child is not with her either. The grandparents have been raising her. What should he do? Do you have any advice? Bruce.
Well, it's a family law question. And so this person needs a family law attorney, and unfortunately probably also needs a criminal defense attorney, because establishing paternity, there's a logical path and set of motions that can be made, but then you also need someone to act as the intercessor between the inmate and the warden and the Department of Corrections. So we can't answer that question. They've got to start with the family law attorney first.
Very good.
But I would commend that person for trying to establish it. That's
absolutely
good for him.
You brought up the Harvey Weinstein situation, Dane, and that reversal, and it had a lot of people saying, what? What led to this reversal as far as where things are now? Because it seems like, hey, this seemed like a pretty clear-cut case, but now here we are reversing things. What happened here?
Well, it was really the rules of evidence. And by that I mean when he was charged, there were only 2 actual counts in his charge. And so 2 women had actual allegations for him to be either guilty or not guilty of. But the prosecution, I think, feeling pressure from the Me Too movement and wanting to give these victims a voice, let multiple, I don't know if it's 50, 100, lots of other women who didn't have actual formal charges against Harvey Weinstein testify at the trial. And so when he was found guilty, his lawyers appealed it and basically said, you should only be allowed to try and have people testify who actually have charges against you and not all these other unnamed or uncharged victims. And that created such an imbalance and unfairness that it was not a fair trial for Harvey Weinstein.
This can be retried, though. Is that my understanding? Because, this seems like it was a misstep. It was an aggressive approach. Perhaps, as you're saying, part of the times there, because the Me Too movement was everywhere, right or wrong in people's opinions. But the aggressive approach led to this reversal. Can it be retried?
Yes, and that is what I imagine prosecutors are deciding right now. I will say that's a very difficult and tall task. One, to get victims to come back out and do that again. I think that was very difficult for them for the re-trauma, but also just the logistics and timeline and amount of money that it would take when, I don't know if you've heard, but there's some other very important cases that are going on in Manhattan courtrooms right now.
Oh, yeah, I've been watching it at the top of the hour. It seems like every day for the last 3 weeks. Bruce, maybe I'll throw this question your way, because you imagine that's got to be in the trial prep, right? This is what we're going to allow, and this is what we're going to pursue. You are, I assume, and you can walk me through the process here because I know you're busy with it, preparing for what the prosecution might be bringing. What are you guys doing when you're preparing for a variety of trials, and what are you expecting the client, if anything, during that time, during trial prep?
What we're expecting from a client depends on the case. Some of our clients are rather detached from defense, not because they don't care about the case, but because given the nature of the accusation, they may not have a lot to contribute. And sometimes we've represented people who are lower functioning and they're not able to contribute that much, but we do try to spend as much time with them as we can. Trial preparation is an extraordinarily laborious and time-consuming process. We spend a lot of time building out, helping us understand what the theory of the case is, all of the witnesses that have to be cross-examined, all of the witnesses we may call, their direct examinations, preparing for what the cross-examination of the prosecutor may be. There are closing arguments. There are various motions. And we do a lot of prep in advance of that, sort of running ideas by what we call focus groups. We actually do a kind of like a mock trial before, and it's something that is very rare in criminal defense firms, more popular in larger plaintiffs' firms in bigger cities. But we do that to give us a better read on what actual citizens, how they will perceive the evidence and the burden of proof and so on.
when you have a variety of trials, how do you work with getting them scheduled out so that you guys are able to be at every client's trial that you're a part of? I mean, let's say, for example, you guys are in 5 trials at any given moment. I mean, do you get much say when it comes to the judge scheduling things out? How does that really work?
We get some say when it comes to that. The problem is we have trials scheduled in federal court, in state court, and in 2 different states. So it's not as though there's a unified scheduling system across the country. Being that we are in private practice, it is easier because we have far fewer cases. We only have about 50 cases total with all 3 lawyers. When I was a public defender many years ago, I had 100 cases. I literally tried 3 cases in a week once about 12 years ago. And it's tough on the clients. It's certainly tough on the defense attorneys, but we try to manage everything, and we tend to be pretty successful in doing that.
I don't know how to ask this in a correct way, so I'm just saying, do you ever just say, nope, I don't want this client? Like, absolutely not. I mean, does that happen, or is it very uncommon that somebody gets rejected to be a client?
It's an extraordinarily rare situation where we reject the client. We do not reject clients because of how odious the charges are. That is not something that we do. We're dyed-in-the-wool criminal defense attorneys. The government's going to bring this charge. We are always representing not just the client, but the Constitution as well. Sometimes the client is really difficult to deal with. If they are not prepared to work with us in defending the case, we reserve the right to turn that case down.
Or if we are fundamentally too busy that we can't give it the attention and the quality that we have come to expect of ourselves, we may say to them, you should have this other law firm handle it. But that's important to reiterate. It is never the charge that makes us decide one way or another. It is usually the client or the amount of work the firm has.
There's a client that's sitting in Manhattan that you referred to earlier. I'm not going to pull you guys in on this unless you absolutely want to, because he seems very difficult as a former president, when we talk about impartial juries, because it's been talked about around the globe. And, I mean, when you have a judge saying, stop talking about this, and then going out and seemingly violating those orders, how do you handle that as somebody who's supposed to represent that client?
If I knew that answer, I mean, Bruce and I maybe would have another high-profile client. But what I'll say about it is, there's a very famous trial lawyer in Florida named David Oscar Marcus. And he is arguably maybe the best living criminal defense lawyer today. And he actually had an interview with the president on whether or not he wanted to be his lawyer. And from what I understand, the way he tells it, they offered him the job. And it could have been obviously the most high of all the high profile cases he's done. It'd be the most high profile case of his life. And he's not his lawyer. And he doesn't elaborate exactly as to why, but the subtext is there's another famous lawyer that Bruce can talk about. And his name is Bennett Williams.
Oh, Edward Bennett Williams, yeah.
And Edward Bennett Williams says, I want a client who I am like the doctor going to surgery. You accept that you will be having surgery. I will be putting you under, and I will wake you up when the case is done. And this gentleman from Florida is more like that, and I think that is why he just knew it would be an impossible task.
When it comes to, let's say, all right, we're going to give it a shot. All right, I'm going to see if I can't rein you in. I'm a professional. I'm going to get you, the best damn representation I can if you just listen to me. And then all of a sudden the trial starts and you ain't listening. Is there anything that prohibits you as a defense attorney that's been hired by that client from walking away from that? Or is it fully within your grasp to say, I'm out of here, you're not listening to me? I'm curious what your response is to that.
Well, it depends on the venue. In Minnesota, an attorney can withdraw from a case, a criminal case, for what is called personal reasons. That is to say, they don't have to justify it. From an ethical perspective, if I cannot get my client on board with what I well and truly believe is the best defense, if they are going to make a choice that is contrary to everything I believe about defending the case, I'm going to withdraw. I have never done that in my career, but I reserve the right to do it. I've dealt with some extraordinarily difficult clients, but it's part of my responsibility to bear that burden.
Ditto.
Well, you have to understand that your clients, you cannot be a lawyer who cuts the moment things get difficult.
Right.
I pride myself in federal court, Bruce, and state court that no matter how difficult the person is, I am going to try to find a way to find common ground, to have the hard conversations so that I can help them, even if they don't realize it, aren't happy with it, and maybe aren't helping themselves. Because it's very easy to cut and run on a client. It is much more difficult to stick it through and try to do justice for them, even when they aren't doing it for themselves.
All right. Fascinating stuff, guys. Tyler, question for the lawyers. Will it state on your criminal record if your firearm privileges are revoked?
Well, what is a criminal record is kind of an open question. So you can look at the Minnesota Court Information System and pull up a history of cases. You can do the same thing in North Dakota. There is no flag on there that indicates whether your firearm privileges are revoked. If you have a question, you're going to have to consult with an attorney.
And do it before, not after.
that seems like a common thing. Like do it ahead of time, boys and girls.
Well, this one especially because up here we are hunters, we are all these things, but there is no real ambiguity in these statutes. If you cannot have a gun and you have one, it's pretty cut and dry.
And then you're going to need a criminal defense attorney for something new.
And then guess what? We're going to tell them how they can get in contact with you guys when they come back. I got to get that final weather update of Too Tall Tom. We got about 10 minutes left here of Afternoons Live. We got time to squeeze in another question or two if you have them at 35270. More with Bruce Ringstrom Jr. and Dane DeKrey next. Well, you just heard. It's Law Talk. Right here on Afternoons Live. Criminal defense attorneys Dane DeKrey, Bruce Ringstrom Jr. Guys, I get so much positive feedback from this hour that we've been doing. I think this is our third time. The wisdom that you guys bring, and just the all-around down-to-earth approach. Thank you for doing it. Thank you for choosing Afternoons Live to do that. But sometimes the questions that come in are more detail-oriented. I mean, it's like they need to reach out to you guys, not just get it answered on the show. Where do they go, Bruce?
Well, they can certainly go online, ringstromdecrey.com, or you can give us a call at 218-284-0484, 218-284-0484, and we'll talk to anyone. If you've got a criminal law-related question, if you have a civil rights-related question, but also if you're looking for an attorney who of a specialty that is not ours, you're welcome to call, and we will do our very best to steer you in the right direction.
I imagine you guys get a lot of calls about a variety of things. I mean, we had that text that came in about a paternity, and you have a family law, and while there might be a criminal aspect to it. So, I mean, people can get referred to then, because that's, I think, got to be the scariest thing. Aside, well, the second scariest one is, okay, I'm in trouble. Number two is, where do I turn? And if it's criminal defense or if it's whatever, it's nice to have a friendly voice on that other end of the phone call, because I feel like I'm in trouble now. And you guys are the place to go for that. We have just a little bit of time. There was a couple of situations that we didn't get to wrap up last time. One was about race statistics. I got a lot of phone calls on that. Let's save that for next month, because we cannot get that in 3 minutes. But we also talked, I think, in our first episode about the Crumley, the parents that had a son that went and did a school shooting. They just now were sentenced, I think, within this last month, to 10 to 15 years in prison. I remember us talking about this being a precedent. I'm curious your reaction to the sentencing of 10 to 15 years for the parents, and what I think might be the first time really being held accountable for what their son did at a school shooting. Bruce, any thoughts on that?
Well, as a private citizen and not as a lawyer, I wonder whether that amount of punishment is appropriate. Certainly, I did not lose a child in that shooting, but I can only imagine that there's a desire for justice, and that's what that's where that sentence came from. On the other hand, I continue to believe that this is a slippery slope, that when we are holding people criminally accountable for the behavior of others, even if they are their own children, we could find this being extended to other situations far less horrifying than school shootings.
Wow. Dane, anything you want to add? This, that, and otherwise?
I hope it's the exception and not the rule. I think that certain circumstances may warrant these sort of outlier cases, but I hope they don't swallow the rule.
Okay. guys, I mean, there's other messages coming in here about the statute of limitations again, about being changed. You got one thing you want to add to this?
Well, you had mentioned earlier talk about the phone.
Yeah, but data, yep.
Yeah, and that's one thing we should talk about next because the Supreme Court, in front of it right now, there's a petition to try to answer this question about compelled password usage. Whether or not we talked about, if you type it in versus your face versus your fingerprint, and it is bubbling up all across the country. Like I said, there are states on either side of it. There are all sorts of law professors who are interested, and the Supreme Court hasn't taken up a Fourth Amendment case, which is what this would be under, unreasonable searches and seizures, in many years.
Yeah.
And so this new court has not ever taken it up. And every once in a while in the Supreme Court, there's some odd bedfellow cases where you don't know where they're going to land. Mm-hmm. On the big ones, we kind of know, or we think we know, but every once in a while in cases like this, you get some weird pairings. And so I hope, for nothing else, to see how that shakes out if they take this case up.
And I'm prepared to take a strong position on this. I think they should rule that this is protected by the Fifth Amendment. This is the content of someone's mind. We're litigating this in a case right now. We just filed a motion to get the contents of a phone excluded because our client was compelled by order of a court to give up the contents of his mind to get in there. So our hope is that these strange bedfellows do come together and it's ruled unconstitutional.
Fellas, professionally done. That is a tease that people have to hang on to for a month about coming back to that. And maybe we'll have a decision by then as far as where things are when it comes to your cell phone. Because it's a whole new thing. I imagine that there's other times where, I know I have only got about 30 seconds here, technology got ahead of what the law is. And this seems to be the case right now, right?
That's what always happens and requires the Supreme Court to revisit its old precedent. We did it in 2016 in a case called Carpenter about cell phones. This is the next frontier of what does your privacy mean in the digital age.
Fellas, we're out of time this month. Let's do this again next month, all right?
Very good.
Always a pleasure. Ringstrom, DeKrey, Law. You can check them out online. And if you need any advice or you need representation, these are the guys you want on your side. This is it for me today. I'm Tyler Axis, your host here on After News Live. I'll be back for more of the show tomorrow. Till then, you drive safely. You take care of yourself.